My name is Anthony Kuhn. I am a managing partner for the Buffalo office here at Tully Rinckey. I'm a 26-year veteran of the Army and Army Reserve, obviously a military law attorney, and I chair our firm's military and national security practice groups. Joining me today is my colleague Eric Duncan, who's also a military law attorney. Eric is a Marine Corps veteran and works with me here in the Buffalo, New York office. And we work together on a lot of the issues that have come up in the 2023 NDAA. So Eric and I prefer to do these types of webinars as a panel discussion because there's some experience that Eric will have that I won't, and vice versa. So thank you for joining me. We appreciate everybody tuning in here today, and we hope that we can answer some questions that you all might have and provide some information, at least the information that we have that's out there so far, and maybe be able to provide you all with some guidance and some expectations on what we should see here in the near future as well, based on the guidance that was in the 2023 NDAA. So some of the material that we're going to cover today, we split it up. Really, there's two topics that we're going to be talking about. There are a few other hot topics that came up in the NDAA. One of them is titling. It's a security clearance issue that we deal with a lot. Well, it's military law, but comes up in the security clearance and national security realm quite a bit. We didn't think we would be able to fit that into this webinar here today, but we hope to be able to do one on that in the near future. So today we'll be talking about the changes to the COVID mandate and the mandate being struck down. And we'll talk about some of the changes to the survivor benefit plan, which likely will affect tens of thousands of people across the United States. So this is just a quick outline of what we'll be chatting about here today. Eric, if you'd like to take the lead.
Yeah, no problem. So the COVID-19 mandate, no longer enforceable. The 2023 NDAA passed just before Christmas, was signed into law by the president. So there's no more vaccine mandate. Now, there's definitely questions that are lingering following that. For some of you that may have received bad paperwork, such as a letter of reprimand, a GOMAR, things like that. And how you being processed for separation right now is going to play out. There's still a lot of unanswered questions, but as of right now, individuals who submitted a religious, administrative, or medical exemption request to the COVID-19 vaccine mandate, and that is the sole basis for their separation, you're no longer going to be processed for separation. For those of you that may have, Article 92 violation for failing to obey that order, plus some other type of misconduct, chances are you may still be processed for separation, depending on what that other misconduct is. But as of right now, there is no vaccine mandate. No service member can be forced to take the vaccine, whether it's, active duty, reserve, cadets, midshipmen, ROTC personnel. So that is the current state of what the COVID-19 vaccine mandate is right now.
All right, so just to be clear, for service members, if I got into trouble and I'm facing the vaccine mandate issue, they're not going to pull bad paper out of my record unless it relates only to the COVID mandate or the COVID vaccine mandate. So that's, I think, an issue that a lot of people need to understand. If there was some type of misconduct related to the COVID mandate, if an individual lost their military composure or did something disrespectful to their chain of command, went AWOL, did something like that, what Eric's saying is there's a possibility that you could still face repercussions for that, but that anybody who followed the rules, submitted their vaccination exemption requests, those individuals, bad paper will be removed from their file. Service members only, not veterans. Bad paper will be removed from their file, and they will be allowed to continue their military career. And for the individuals who are currently facing separation, I know we've dealt with this a few times here in the recent past. Some people are at the end of the line. I mean, they've been processed, they've moved their family, they've done a lot and expecting to be out of the military. And maybe they're in that last week of processing. The military has put the brakes on some of that, and they're trying to force people to come back to wherever they were, which has caused a hardship for some individuals. So, there's maybe a potential there to do a resignation or a hardship discharge, maybe negotiate with the command to still get out of the military based on the actions that service member has taken. But unfortunately, you're not out of the military yet. So the unit can pull you back if you're not fully processed yet. And then as far as the cadets and midshipmen, individuals in these ROTC units that were going through the process, some of them believe that they're still being forced to get the COVID vaccine based on the COVID-19 mandate. We've had a lot of calls about that in the past month or so.
Yeah.
That's not true. That's the universities, and I believe all cases where individuals think that the ROTC detachment is enforcing it. What the ROTC detachment is doing is they're enforcing the university's policy. So if the university says you have to have a COVID vaccine, the ROTC detachment can't refuse to enforce the university's policy. That's no longer a military issue. That's now an issue between you and that university where you are. So if that comes up and you want assistance with that issue, you're probably going to have to find an attorney locally there, because it's going to, local laws and local civil rules are going to govern what you can do in that area and what attorney can be involved. But if it's a military issue, it can be a military law attorney anywhere in the country. Get that good? Okay, let's see. All right. Want to talk about the differences between the service members and veterans and how this is?
Yeah, that's not a problem. So for service members, the repeal of the vaccine mandate, like we said, it halts separations, but only if your separation is predicated solely upon refusal to receive the vaccine and you submitted some type of exemption request, whether it was a religious accommodation request, a medical waiver request, or one based on administrative. Those administrative requests were typically individuals who were just about to ETS or out process out of the military, only had maybe a month or two left. So if your separation was based on that and you hadn't been separated yet, and by separated I mean had your separation orders issued, you're in the clear for now. As far as removing the bad paperwork, this is supposed to be done automatically, and if anybody on this call has bad paperwork and meets one of those criteria I listed above, make sure you're checking in with your command to see if that paperwork was actually removed and is done so in a timely manner. Because that bottom point, promotions, anybody who has been up for a promotion board and potentially has bad paperwork in there knows how detrimental that can be to career progression. So you want to make sure not only that the paperwork's getting removed, but you want to make sure it's getting removed in a timely manner. If you're up for a promotion board, 3 months down the road from now, I would check in at least a month or so before that board to make sure that paperwork's been removed, because you don't want it being reviewed. For veterans, it's a whole different process for fixing what's already been done to you. Bad paperwork is not going to be removed. You would have to petition your branch's respective board to remove that. For the Army, it's the Department of Army Suitability Evaluation Board. That would be your first stop. If that didn't work there, you would then have to go to one of the respective board for correction military records. For the Army, Air Force, Navy, Marine Corps fall under the BCNR, which is the Board for Correction and Naval Records. As far as discharges go, the way the mandate or the 2023 NDAA was drafted, nobody was supposed to receive anything other than a general discharge characterization. Now that is only if your discharge is based solely upon refusal to receive the vaccine and you've submitted one of those 3 exemption requests we discussed previously. If you have some type of other misconduct, that may justify them issuing you something other than a general, meaning an OTH. So you got to be careful there, but you do want to go, you're still going to have to go to one of your respective BCNR or BCMRs. Now, if you went through an administrative separation board, you may have received an OTH. If you didn't go through that type of board, you shouldn't have that type of discharge characterization. The other issue that you may see is separation for 2-time non-select. Again, this goes back to having bad paperwork in your file related to the vaccine mandate, your refusal to do so, and that paperwork being reviewed during the promotion process. It can get pretty complicated, but you are going to have to go to your respective branch's board for correction military records in order to, 1, request that paperwork be removed, and then 2, request a special selection board to reconsider you for promotion. As far as getting back in, that goes right back to your respective board for correction military / naval records. you're going to be looking at correcting some of the administrative data that you'll find on your DD-214, such as your reenlistment code. You got anything to add on that?
Yeah, so we did a discharge review board webinar in the past together, right?
Yep.
So that should be searchable if you follow any of our Tully Rinckey webinars on YouTube and probably on our website as well. You can go ahead and review. We've already done one. I think it was a little over an hour long webinar on discharge review boards, Eric and I together. Back in October.
Yeah, so.
And we go through a lot of what Eric's talking about right now. So the negative discharges, we know that statistics have been published by the military. I've been in the military 26 years, so I know they're probably not as accurate as the military is presenting them to be. But there are statistics that have been published. Those statistics claim that I think it was around 86% of the discharges were general. There were some honorable, and then there were also some other than honorable or OTH discharges. So those negative ones, those are really the ones you want to go after. The problem with this is that it's not going to be as easy as just doing a DD-149 and submitting that to the board and thinking that they owe you something, because they don't. You didn't comply with the rule and you got kicked out of the military for that. So you will not be able to show most likely that there's an error or injustice, which is the standard for the board, or that there is an inequity or impropriety. What you might be able to do is the inequity. So if you start with the discharge review board and you make an equity argument, maybe arguing that the other service members are able to be retained and their bad paper is being removed from their file, so yours should be as well, as a matter of equity. It's probably the best argument, but you're going to want a good legal brief and you're going to want to support those arguments. So don't think that you're just going to file a form and they're going to change your discharge. Get some help with it, write a good legal brief, and make sure that your packet is put together well so that you don't get denied that discharge upgrade request. But there's no reason why everybody with a general or an other than honorable shouldn't be going after an honorable discharge. We've had some issues in the past, like misconduct caused by PTSD, individuals separated under don't ask, don't tell. There have been a number of different publications or memos that have come out and directed the board to take certain types of actions based on those circumstances. That hasn't happened in this case yet. There hasn't been a memo to the boards telling them to grant or liberally grant discharge upgrades. That's probably going to happen in the future, but there's no guarantee and it hasn't happened yet. So, you're going to have to work a little bit to get those discharge upgrades and to get that bad paper removed from your file, especially if you want to go back into the military. All right. Want to keep going or want me to jump in?
You want to jump in?
Sure. So applying to the boards here, we just talked about this quite a bit, but some of the things that the board will be able to help you with is that discharge upgrade. If you were kicked out of the military and you don't have an honorable discharge, you should have an honorable discharge if it was just for the COVID vaccine mandate. You stuck to your guns, you went with health first, science first, whatever your reason is for it, and you didn't believe in the mandate or believe that there was actually an FDA approved vaccine at the time. Whatever the reason is, we can make those arguments, you can make those arguments, and you can make that argument of equity as well. So discharge upgrades are one of the things that can be changed by these boards. Your re-entry code, that's a code that's down in the corner of your DD-214. If you have a re-entry or an RE code 1, then you're in good shape. You don't have to worry about getting that changed. It's easy to get back into the military. A 2, you should still be able to get back into the military. Anybody on this call probably knows that our numbers are really bad right now, in part because of this COVID mandate, in part because of kicking people out over the COVID mandate. So the numbers are really bad right now. So somebody with a 2 is most likely still going to be able to get back in. Someone with a 3 might still be able to get a waiver to get back in. But if you have a 4, you're probably not going to be able to get back in. So you're going to want to file an application with the boards to upgrade your RE code so that you can re-enter the military. You're going to want to try to get bad paper pulled from your file so you don't have to worry about getting a waiver for whatever that misconduct is or whatever that record of misconduct is that's in your personnel file. And any record corrections, in your DD-214, you'll have a narrative reason for separation. Maybe you disagree now with that narrative reason for separation. Maybe it says misconduct or something like that. That's something that can be challenged and changed at the boards as well. And then you heard Eric mention this briefly earlier, the special selection board. So this is especially for officers who were passed over twice, not promoted, and separated as a result. Maybe that's because you refused to get the COVID vaccine. If that's the case, and it put bad paper in your file, it caused you to get passed over, it caused you to be separated from the military, one of the things that you'll want to argue is that your record should be corrected, and then your record should go before a special selection board. So, but for that bad paper, would you have been promoted?
I've actually won a few of those.
Yep. So
it's possible. You got to request it.
And you have to have your record corrected first. So you have to have that negative paper taken out of your file, and then your file gets reviewed under the same standards as everybody else that was reviewed during that fiscal year's promotion board. And if you then get picked up, then they can promote you and backdate it and take those actions. And maybe you can go back into the military and stay in the military at that time. Again, down here with reentry, so the board is one option, but what you need to do immediately if you're looking at reentering and you were separated based on a COVID mandate is you need to go and speak with a recruiter immediately. So there are going to be some timelines that you'll have to meet. If you are a disabled veteran, for example, you've got a VA rating, and you want to go back into the military, a lot of us have a high VA rating. You know, combat veterans, people who got blown up by IEDs, suffered TBIs, have bad knees from 20 years of military service. There's a lot of different conditions that individuals develop over 20 years of military service. Some people were chased out of the military with more than 15 years of service. If that happened and you want to get back in and try to get to your 20, you need to hurry up and try to get back in, because there is a limit for when you'll have to go back through MEPS to do a full medical evaluation all over again.
It's a year, right?
I think it's 2 years.
2 years.
So if you wait too long and you have to go back to MEPS for a full medical evaluation, they're most likely not going to clear you if you've got a bunch of service-connected conditions. But if you go back in quickly, talk to a recruiter, tell them you want to be prior service, you want to come back in, there's a whole bunch of people already doing it. Talk to a recruiter as prior service, join back up, and you can most likely avoid a lot of these hoops that you'd have to jump through if you wait too long. Then another thing that we're seeing, I don't know if you've seen this yet, some National Guard, Army National Guard units are trying to pull people back in.
I haven't run into that yet.
So it's happened. We've got a couple calls about it this week where individuals in the National Guard were actually separated. You know, they got their, not a DD-214, but their NGB 22 and their discharge, and they were given a general discharge or something like that. Well, now these Guard units, some of them are trying to pull the people back in. And they're saying, you know, that you're required, the state's bringing you back to drilling status. You don't really have a choice in the matter. If that happens, there's most likely room to negotiate. I'm not aware, and again, every part of this COVID mandate issue is new. Every time it happens, it's a new policy. So service members who don't want to go back in are most likely able to stay in whatever status they're in, that separated status. But there's a possibility that these National Guard units can pull them back in if they need to complete a contractual obligation or something like that. But, reach out. If it's not us, reach out to another military law attorney, talk to somebody, get somebody to help negotiate that for you. We negotiate separations from the National Guard fairly frequently. Oh. And, the reality is a lot of those commanders don't want the service member to be there if the service member doesn't want to be there. The tricky thing you get into here with the National Guard, as opposed to any of the federal services, the Army Reserve, the Air Force Reserve, is that the National Guard, they can put a warrant out for your arrest. So if they tell you that you're back to drilling status and you decide you're not going to go, it's not like the Army Reserve where they're just going to list you as AWOL. The National Guard can actually put out a state warrant for your arrest, and they can come and have you detained for missing a drill weekend. That's not going to happen in any of the federal branches, but that can happen and does happen with the state National Guards. So keep that in mind. If you're told it's mandatory, you have to report somewhere, and you don't, then you're at least playing with the idea or the risk of them coming and having you detained. So contact an attorney, get some assistance from somebody, and have them help you negotiate a separation if that's what you want. All right, we're going to move on now to talk about the survivor benefit plan. And we flipped these, Eric and I talked, and Eric was going to do most of the talking about the COVID mandate. and I'm going to do most of the talking about the survivor benefit plan. But in hindsight, Eric probably knows more about survivor benefit plan than I do. But we're going to talk through both of these together, just because Eric deals with this pretty much every day.
Yeah, I do.
So we're going to talk through SBP, and if you have anything you want to add, feel free to jump in. But what is it? So for those of you that aren't familiar with the survivor benefit plan, when an individual when an individual qualifies for retirement from the military, they can basically take out an insurance on their retirement, and you pay a premium out of your pension for what's called an annuity. So if something happens to that service member and they pass away before their spouse or before their children or whomever they name as the beneficiary, if the service member passes away first, then that insurance policy kicks in and that beneficiary gets an annuity. So a portion of what would have been the pension. And that's to help that service member's dependents, whether it's a spouse or children. And it's really just kind of gambling on just like any other life insurance policy, but you're gambling on your pension. Do you want to pay a small portion, and if you die before your spouse, then your spouse still gets your pension? Or do you want to say, no, I'm not going to do that, and then if you die first, there's no pension? So most people opt into SBP now because it's difficult to opt out, but most people have historically opted into SBP. And what happens is when an individual gets out of the military, this happens all the time. I have no doubt that it happens because I've been told, I don't know how many times, that it happened to individuals that I spoke with. When an individual gets out of the military and SBP is explained to them, a lot of times they're told, well, don't worry, there's going to be an open season. And it's true, Congress did codify an open season for SBP, and with the expectation that there are going to be open seasons from time to time where service members will be able to change their election. And what is an election? So the election is at the time for a reservist, when you get your 20-year letter, you can make an election at that time. And for other individuals, when you leave the military, you can make an election at that time. And there are other triggering events, which we'll talk about in a minute, but you make an election. You either elect to have this SBP insurance or you elect not to. And now, a spouse, if you elect not to have this SBP coverage and you're married at the time, your spouse actually has to sign off on that waiver of SBP or that refusal of SBP. Your spouse has to sign off and her signature has to be notarized. So if you get out of the military now and you say, nope, I'm not going to do SBP even though I'm married, your spouse is contacted and has to sign a notarized document saying that she is aware or he is aware and that they agree. So that's a change. It used to be the service member alone could opt out and the spouse had no say in it. And when that happened, the spouse often had no idea what was going on. Most of the people, the service members often have no idea what's going on because most people don't really understand SBP all that well. So just know that now a service member can no longer opt out unless the spouse signs off on it. You can also make an election for your children, and there's an age cap on that. So if your children are 18 or under, you can elect your children as your beneficiary. You can elect spouse and children. There's certain elections that you can make for multiple people, and just know that your children have an age cap. So it's 18 unless they are enrolled in school, then it's 22. But that's it. After that, they're done. They can't be part of your SBP plan or insurance policy anymore. So what has changed in this new NDAA? As I said earlier, they have Congress wanted these open seasons to take place occasionally, but I don't think there's ever been very clear guidance, and the government certainly hasn't followed any guidance about open seasons. So some people, it's been over a decade.
Maybe 3 in the last 25 years.
Yeah, there's been very few open seasons. And what happens is you've got some service members who've now been waiting more than a decade to change their election, and they've been unable to do that. And during that time period, some service members, unfortunately, have passed away, and their spouses are here, with no pension, even though that service member repeatedly tried to change the election, but the government wouldn't allow it. So the NDAA has now created, through that NDAA, an open season, which started in December of 2022 and runs until January 1st, 2024. But they issued no policy or forms or anything. The NDAA is just guidance to the government saying you need to create an open season. Now the government is scrambling to figure out what that looks like because they don't do it often enough. So we're in the middle of that right now. So what are the changes? It depends. What was your previous election? If you previously elected to have this SBP coverage and now you want to shut it off, then okay, you can do that. That's the biggest change right now. Right now, as of I think yesterday, actually they updated the site and they created forms and a policy and they sent emails out to retirees. As of yesterday or the day before, you can now shut off your SBP premium. If you're paying that premium for SBP coverage, you can now cancel it. There's a policy in place. The form has been created. There's now a website through DFAS that talks about it and provides information about this topic. But as of yesterday or the day before, you can now shut off your SBP payments. You will not recoup any of those funds. So if you have paid for SBP for the past decade and you've been trying to turn it off all that time, you're not going to recoup any of those funds. So don't expect that you will. But you can shut it off and stop paying those funds moving forward.
And just to touch on that too, I think, so those SBP premiums are only collected for, I believe, the first 360 months. So if you're, approaching that 360 month mark and you still, have a named beneficiary that's living, it may make sense to just keep that in play. You're providing a little bit of protection down the road for them and not really giving up too much more up front, and you're getting what you paid for.
Agreed. Yep. So there's a cap on how many premiums you'll have to pay. And if you're approaching paying it off, then you might as well just keep it. Are you adding SBP? Are you trying to add a new beneficiary? Are you trying to turn on SBP when you haven't in the past? And I know that, we deal with multiple clients who are trying to help work this out for, and we have been for years because it's been so difficult to do. The answer is going to be yes, but there is no policy or forms in place to do that right now. So while the NDAA has called for an open season and the government is working on figuring out how to turn SBP on for all of these people who have been trying to change their election for all of these years, they have not yet created the policy. They have not yet created the form that is going to have to be completed to make this happen. So just keep an eye out on this, and we will follow our website if you want to. And as we'll publish articles and we'll do things like this as the changes come into effect. And we will be, I'm sure, representing quite a few people and assisting them with getting their SBP turned back on. Just know that if you are turning on SBP at this time, that you are going to have to catch up on the premiums. So if you waived your election 5 years ago and now you're changing that and you want SBP, you're going to have to pay those back premiums. So you'll have to be prepared for that if you decide that you want to turn SBP on now. And as we discussed earlier, if you want to shut it off and you currently have a spouse or an ex-spouse and you want to shut off SBP, you're not going to be able to do it unless that spouse provides a notarized signature, a document with a notarized signature on it, or there's a court order. If you have a court order, say you got divorced and you have a court order, then you're not going to need that notarized document as long as you have the court order. And DFAS is very funny about the language that goes into these divorce documents. So make sure that your divorce attorney is tracking what a military retirement looks like and doing some research on that, because there's very specific language that has to be included in these divorce documents.
And I think 9 times out of 10, the SBP cases I get are because the divorce attorney didn't understand or know about the specific language DFAS was looking for. We'll typically see this, down the road where the wife files a deemed election. She thinks everything is good. The military retiree ends up passing away, and the beneficiary of that annuity submits application for payment, and that application gets denied because of the language that was in that divorce decree at that time.
All right, agreed. So who can you name? who can your beneficiary be? And I talked through this a little bit just briefly already. It can be a new spouse. It can be a former spouse. It can be, you can have SBP on somebody, but they may lose SBP coverage if they get married before age 55, if they're a former spouse or if the service member dies, and they get remarried before age 55, they could lose those SBP benefits. It could be in a court order. So if you get divorced and there's a court order that specifies that the former spouse is entitled to SBP coverage or that SBP protection, then you are required to ensure that you opt in for that SBP coverage. We see this quite often where the court documents specifically state that the individual is going to have SBP protection, and then they don't make the election. And back when this was all going on, up until recently, there was no requirement for that spouse's signature, that notarized spouse's signature, so people were able to get away with it. You're not going to be able to get away with it anymore. So.
And that's actually why they went ahead and made that deemed election process, is they realized, whether it was just the retiree forgetting, maybe malicious vindictive spite, they weren't submitting that paperwork. Years down the road, the surviving spouse or former spouse was, really left with no recourse, and that's why Congress came up with the deemed election.
And that's the next bullet here. So deemed elections must be made by the former spouse within 1 year of that court order. So usually it's the divorce paperwork is published, finalized. That former spouse has 1 year to then file with DFAS, file a deemed election with DFAS, expressing their interest to ensure that their military spouse elects SBP coverage. And DFAS will honor that deemed election. And if not, they'll correct it later, which we've had some success challenging, similar cases.
Yeah, I think I won one at the board just recently, actually. So there's ways to get around that, but my recommendation would always be, if you find yourself in that situation where you're divorcing from a military retiree, SBP is going to be part of what you're receiving. The day after that divorce decree or judgment of divorce gets finalized, go to your attorney. Hopefully he has knowledge about this stuff. If not, find somebody that does. Submit the proper paperwork, make sure you have receipt, follow back up with DFAS until they confirm receipt, because you don't want to find yourself in a position 10, 15 years down the road where your former spouse has passed away and you've applied for benefits and you find out, hey, we never received that deemed election. It happens more often than you think.
Yeah, and the reality is that the majority of service members and their attorneys have never really followed any of the rules for SBP and don't really understand how it works. So unless you're working in this space, you're not really familiar with these rules. There's a lot of rules in SBP, and it's why so many people want to change their elections now, because they didn't know the rules when something happened, a life experience or a life event, and they didn't make their elections within a lot of time. So hopefully this will create an opportunity for most, if not everybody, to fix those elections.
Yeah.
We talked about the children already, so it's unmarried children, and they have to be below the age of 18, and then if they're in college, below the age of 22 or younger, 18 and under, and 22 and under for for college age children. And finally, how do you change your election? Are there any other ways other than an open season to change their election? And the answer to that is yes. We've talked about some of them. So if you have some type of qualifying life event, if there's a marriage, if there's a divorce, if there's a death, under certain circumstances, the service member is going to be able to reach out to DFAS and change their election. So if you have one of these qualifying life events, you usually have 1 year to reach out to DFAS and change your election. So that's just something to keep in mind. Don't wait for open season if that is the case. If you got divorced within a year, if your service member, husband or wife passed away within the past year, don't wait for open season to publish guidance on how you should handle that situation. You should notify DFAS now that you want to make an election for SBP and see if there's an opportunity for you to change an election now.
So there's one qualifying event that's not up on the slide, but as a military retiree, you get your 20-year letter. Say you have no wife, no dependent children. If for some reason down the road you acquire a dependent child, that is a qualifying life event. If you want to provide SBP coverage for that child, reach out right away, establish him or her as a beneficiary, and make sure you're providing something for that child moving forward in the event you pass away before he or she turns 18 or 22.
And I did miss on this last slide, all the way down here at the bottom in the fine print, a natural interested person. So there is this misconception that you can only name a spouse or a child for SBP, and that's not actually true. So you can name a natural interested person, and the definition on this is kind of vague. But if it's somebody who should have an interest in your retirement, it's somebody you're so close with that they can make an argument that they should have an interest in a portion of your pension should you die first, then you can make what is called an NIP election for SBP, and that's a natural interested person. Pretty easy to find this on the DFAS website if you want to look it up and check this out in more detail. But the difference between these other SBP elections and an NIP election is that you can cancel that at any time. You don't have to wait for an open season or for any other circumstances. If you elect a natural interested person instead of a spouse or a child of yours, then you can, and I should say that the child obviously needs to be your legal child. It can't be somebody else's child below the age of 18. You actually have to be the parent of that child. They have to be your legal child. So a natural interested person could be somebody that you've raised as your own child, but legally they're not your child. It could be somebody under similar circumstances, and you can cancel that at any time. All right, that gets us through all the material. We did have a couple of questions that came in. One of them was a question about enforcing the COVID vaccine mandate for new recruits, and at least the question was posed in a way that the individual asking the question believed that new recruits are required to have the COVID vaccine, and that's not accurate. So if an individual wants to join the military now, it is a blanket rescission of the COVID mandate. There is no longer a mandate to have the COVID-19 vaccine. So if you want to join the military and you do not have the COVID vaccine, it doesn't matter. You can join the military because there is no longer a mandate that service members have a COVID-19 vaccine. So that's gone. Try not to worry about that. If you know somebody who is telling you they'd like to join the military but they are not vaccinated, let them know that they don't have to be vaccinated. There is no requirement to be vaccinated. Any other questions come through that you want to?
That looks like a personal question.
If anybody does have a question, please submit that in the chat so I can send it over to our presenters.
Yeah, no.
No, that one. That's a
okay. Yeah, we're not going to get into like personal facts. If you have something that you'd like to chat about, we'll be happy to chat with you offline. But we're not going to get into personal information here during the webinar. So we'd like to thank you all for your time, and keep an eye out for more of these. We'll be doing these more frequently. We were picking up steam a little bit there leading into the holidays, and then
kind of slowed down
the holidays slowed us down a little bit. So we're ramping back up. We will be running a lot of future webinars here on military topics, national security topics, security clearance topics, things of that nature. But if anybody has any questions, you want to follow up in more detail, feel free to reach out to me and or Eric. We'll be happy to help you out. Thank you all. Have a good night.